Welcome to our podcast, Was Justice Delivered? Your go-to source for interesting, provocative, and in-depth legal analysis. I'm your host, Dror Bikel. In today's episode, we're going to speak with two attorneys who have practiced in the area of domestic violence literally for decades. They are two of the premier attorneys in New York in this area. Cardi is the founding partner of Cardi and Edgar, a boutique law firm specializing in family and matrimonial law. She is a former criminal defense attorney for the Legal Aid Society of New York, where she tried major felony cases. Dawn held the prestigious position of supervising an entire unit of trial attorneys. She later became an assistant attorney general for the state of New York. Dawn is considered to be an expert in cases involving domestic violence in both criminal and civil courts. She has defended women who have committed crimes because they feared being battered by the men who brutalized them. Dawn has done extensive pro bono work for Network for Women's Services and Sanctuary for Families. She has lectured on a variety of subjects, including on the rape trauma syndrome, battered women syndrome, and coercive control. Dawn, welcome to the podcast.
Good morning, Dror. Thanks for having me.
Our second guest is Philip Katz. Phil is a partner in the firm of Fink & Katz, a boutique law firm specializing in family law and criminal defense. Phil is president of the assigned counsel panel in Manhattan Family Court and vice president of the Assigned Counsel Association of New York State. Phil is a leader in fighting for family rights on the Assigned Counsel panels statewide. He is certified to assist indigent litigants and children in family trial and appellate panels in Manhattan. Phil practices regularly in various courts in New York, where he has represented thousands of clients, both adults and children. Phil is also an assistant professor of criminal justice at Farmingdale State University. He has published numerous articles in the area of family law and domestic violence. He frequently chairs panels in continuing legal education in the area of domestic violence. And Phil speaks fluent Japanese and serves as a volunteer firefighter and emergency medical technician. Phil Katz, welcome to the podcast.
Dror, it's a pleasure, and I appreciate you having me on today.
Such rock star guests today. I'm humbled as a fellow matrimonial attorney. Dawn, let me start with you. How did you get into this area of representing clients who are victims of domestic violence?
So when I was growing up, I lived in a family where there was domestic violence. There were generations of women who had experienced domestic violence, and obviously I was very affected by it and wanted to try to understand it and wanted to try to understand all the aspects of it. You know, why didn't these women leave? What was going on in their lives? What was going on in the relationship with the family and the children? And so from very early on, I was very, very interested in doing work in this area because I think it's work that needs to be done.
That's so fascinating. I did not know that you had experienced it as a child. Phil, what about you? How did you get into this area?
So life, you never know what life's going to throw at you. And you had indicated in introducing me that I speak Japanese. And sort of that's where my story in getting involved in this area began. I initially never intended to go into family law or anything related to that. And I started out doing immigration law as someone who could speak Japanese, assisting Japanese clients a lot with marriages. And I found a lot of these marriages were resulting in domestic violence situations. And more often than not, unfortunately, I was assisting clients in family court, securing orders of protection as a result of some of these marriage situations that went bad. It opened my eyes up to a horrible situation, a situation that clearly didn't have enough attorneys who were focused in on it. And so I slowly but surely became more and more familiar with the family courts, the Supreme Courts, the criminal court in dealing with these domestic violence situations. And that became my focus. And I decided a few decades ago to changed my focus from immigration to family law, and I've never looked back.
And between the two of you, you've literally represented thousands and thousands of clients in this area. Don, let me ask you, how do you know? So if somebody comes into your office and they don't talk a lot, they're kind of shut down, they're not giving you a lot of information. How do you know that they're victims of domestic violence?
You know, Joe, I've been doing this for so long and have learned so much that I can hear somebody's story. And how do I know? I often know by the demeanor of the person who's talking to me. I know by the look in their eyes. There's often a fear. I often have to talk to them about trust. I often have to say to them, whatever you tell me, no one else will know unless you give me permission. But you know, by virtue of the story of their marriage or the story of their relationship or the story of what got them an order of protection.
Right. Well, what if they come to you and they don't have an order of protection, they don't have anything? Is there anything you can add to what Don said other than, there's that look, right?
Yeah.
You kind of see it in their eyes and the body language.
I mean, I would say that in addition to certainly agreeing with all that Dawn is saying, I think there is something to be said for learning about trauma-informed interviewing, because when you have a victim, oftentimes their story isn't linear. Oftentimes their story doesn't make sense. And when you hear it at first blush, and oftentimes the way you question that person can lead to you getting more information and really understanding the story, or getting nothing and them sort of retreating into themselves. So it's very complex. I don't know that if I could do this for 50 years, I would be an expert in it, because you just start to get a sense. But at the end of the day, you really just need to proceed with caution, understand what happens in a victim's psyche, and try to put yourself in their shoes. And then you could only begin to start to assess these things. And you never can be 100% sure, but you can get pretty close.
What happens? Oh, go ahead, Don.
Let me just say one other thing.
Yeah, of course.
I also find that women who are very highly educated and professional women have a very difficult time acknowledging that they are victims of physical violence as well as coercive control. So you have to be sensitive to that also. You can't make assumptions about who people are and what they've experienced from their socioeconomic level.
Yeah, their view of themselves doesn't conform with what's happening in their relationship.
Correct.
I would add to that, although it is a small minority of the cases that come loose across my desk, when there is a male who is a victim of a DV situation, that type of view of themselves, their worldview of themselves, makes them reluctant to come in and report that. So there is a small cadre of DV victims that come across my office that are male victims, and they're very reluctant, just like the professionals that Dawn is talking about, in terms of women.
Phil, what happens when it's so obvious that, and you believe the client that comes in, it's obvious they're victims, they're in an ongoing abusive relationship, there's some physical violence, and they refuse to act. They don't want to call the police, they don't want you to get an order of protection, but they've consulted with you. What do you tell them?
Well, I try to make them feel very comfortable with me, and I try to let them know that my door is open to them if and when they're ready. You can't force somebody to follow that's not comfortable doing so. The best you can do is make them comfortable with you, inform them of their rights, inform them of what protections are available, and again, leave that door open. And more often than not, they do ultimately come back when they need your help.
Do you give them, go ahead, Don.
I also think that if I can steer them to get some therapy, like Safe Horizons or private therapists I know who have an expertise in this area, I try to steer them in that direction in the hopes that they get the strength necessary to make that decision, which your listeners should know it is a very frightening decision to make. And you only have to hit somebody once before they are afraid to be hit again. So it doesn't have to be beating after beating, although that happens. It has to be, how much fear have you placed and how vulnerable is this family? And the threat is always, I'm going to take your children away.
Right. Yeah. You hear that all the time, right? Like,
Yeah.
if you do something, the kids will stay with me. You'll be on your own.
And I mean, that's true. And again, that was very true in those immigration situations, especially. So that's where I saw a lot of it. And I still see a lot of it.
Dawn, do you give any advice to people you believe to be victims, such as recording what happens at home, keeping a diary, contemporaneous phone calls with friends? Because, this E. Jean Carroll lawsuit with Donald Trump, the plaintiff made some contemporaneous phone calls after the alleged incident to a friend and described what happened, and that gave her some credibility. So I'm wondering, in these kind of domestic violence cases, do you tell clients, here are some things you can do to help yourself?
Absolutely, Dror. A log is a really important thing, as long as it's in a place where the perpetrator can't find it. And you have to remember that. I always ask them about their passwords. I always ask them about places they can keep information private, move it off out of the apartment, because typically the control person may be putting spyware on their computer and doing other things. Contemporaneous reports also are really, really important. Tell your friend, tell your sister, tell somebody that you care about who will keep your confidence.
What about you, Phil? Do you tell clients to record it all, or is that a little too aggressive?
No, it's not too aggressive. But one thing you always need to make sure is what the laws are relative to recording, because New York, for example, permits it as long as one party is aware. But if you're dealing with somebody who has somebody across state lines, certain states don't permit it. So you have to be a little bit careful about that. And I found that I've sort of also become a little bit technologically savvy, trying to help my clients in getting the latest products to do these things. I mean, there are recording devices all over your house that you don't necessarily have to go out and get anything to protect yourself and make a log of these things.
Have you ever? Yeah, go ahead, Don.
I also have told people that if they feel comfortable doing this, that once a person starts to either go forward with them or attack them or threaten them with bodily injury, take out that iPhone and start recording if you feel comfortable, because that person will back off.
Right.
And that has helped people, but that can also work against you, because it can infuriate someone who has no control. So you have to weigh the situation.
What about reporting something to the local DV officer, domestic violence officer at the local precinct? I mean, that also goes both ways, right? Because then you may have the police coming around and checking up, and so it could be a deterrence. But as you said, Dawn, that could also potentially infuriate the perpetrator, right?
Absolutely. I mean, if the police show up at the door and that woman has not expected it or even wanted it, and they don't respect her, then she's in danger. And that's not a good thing.
Phil, let me ask you, what do you do in situations where somebody comes to you and claims domestic violence, but you don't believe them? Has that ever happened? I mean, I represent a client whose wife claims that he raped her, but he didn't. It's all recorded. He didn't. The police did a check. They didn't believe her, and she never followed up on it. Have you had that situation?
So once in a while you do get those situations, but I would say that typically those types of allegations are made by somebody who has another underlying issue that you may want to try to help them with. They may have a mental illness issue. There may be something else going on there. So I probably would, if I do not believe them, I wouldn't necessarily discourage them from filing and having a fact finder make the determination, because Again, as I said at the beginning, you never know. However, I might simultaneously encourage this person to get some additional help in exploring the allegations and exploring why the allegations were made. And perhaps there may be a better way to heal this person who I have a hunch may be not telling the truth. While, again, I would never discourage anybody from following who is making an allegation, regardless of what my sense was, because my sense isn't 100% right.
One of the most... yeah, go ahead, Don.
I think that, unfortunately, there are situations where they're in the midst of a divorce, and in order to get a partner, a spouse excluded, really, you need something like an order of protection, and you need behavior that rises to the level of exclusion. And those cases are difficult because you never want to deny a person who's been a victim the support that they need. On the other hand, there can be manipulation, and it can be manipulation at the encouragement, unfortunately, of some of our colleagues.
Yeah.
So I'm very careful with that. I look into the history, but I don't like to deny support for someone who says they've been a victim. And I'm much like Phil, let a judge decide.
Right. What court do you recommend filing a claim or for the clients to pursue their rights? In other words, there's the criminal courts and the district attorney and the penal laws, and you have the civil court, family court, and Supreme Court, where the penal laws are kind of quasi-criminal, right? So, Phil, what court do you generally, if you believe that a client is a victim of domestic violence, where do you pursue this?
So the answer, if you ask me, is both. And the reason I say both is because you can file a case in criminal court. Well, I shouldn't say you file it. You can convince an officer to make an arrest, and the assistant district attorney can actually prepare the charges, and it can become a criminal case. And that's fast if it happens, usually. The problem with that, I find as of late, is that the district attorney's offices in all of the boroughs of New York are completely overwhelmed. They are required to, without getting into too much of the weeds on it, they have certain time limits in which they have to file cases. And they're often prioritizing things, and they decide to let these cases go, which is quite frankly horrible, but it's a reality of the limited resources. And often they're directed to go to victims, directed to go to family court. So my suggestion always is go to both places. If the criminal case resolves itself with a disposition where you have an order of protection, then you can always withdraw in family court. You don't necessarily need both. But I would say go both places, and hopefully the criminal case proceeds to a result that gets the order of protection. And if it doesn't, you proceed in family court.
What about you, Dawn? Do you have a preference?
I think you can get a temporary ex parte order a lot faster in family court than you can waiting for a police officer or a district attorney to decide whether or not they're going to prosecute. Unless it's really serious injury, then they're going to do it immediately. And then hopefully you will get the police and the prosecutor to prosecute in criminal court. But the temporary ex parte order can be very helpful and very expeditious. I would try that first if I'm not sure that the person is going to be arrested. But I do agree with Phil about the district attorneys in all of the boroughs are overwhelmed with cases, and sometimes these cases are swept aside, but also they have to deal with victims who are ambivalent and who may make a report, and then for all kinds of reasons, financial, family pressure, somebody's going to lose their job, he apologizes for the 410th time, they'll back off. And the assistants, in fairness to them, they don't have time to do what needs to be done to help this person follow through, because this person is terrified.
And we do know that in the criminal courts, it's a higher burden of proof, right? In the criminal court, it's beyond a reasonable doubt. In the civil court, even though it involves the penal code, you have this preponderance standard, which is a lower standard. It's like 51%, right? So when you go to trial on these cases, Phil, I assume you want to be, I mean, you're not going to go to trial in the criminal court because it's a district attorney, but, in terms of your proofs, it's easier in family court, right?
Yes, in terms of proofs, of course, it's easier in family court. But if you can succeed in criminal court, that's always the better place to go. Because if you succeed there, frankly, you can go back to family court. And even if you didn't want to withdraw it, you could file papers indicating that there was a decision and basically ask for a summary judgment. That works a lot of times too if the allegations are exactly the same.
Don, you mentioned that word ex parte. What happens? So somebody comes to your office and you decide, okay, we need to go to court. What are the first steps? What's the first thing you do?
The first thing we do is obviously talk with the person in order for us to draft what's called the petition. And your listeners should also understand that you don't need a lawyer to do that. If you don't have a lawyer, you can't afford a lawyer, you can go to the family court and do it on your own. But that's the first step. Draft that petition. And we try to draft it really, really carefully. And we try to include as much information as we can. And then the person swears to the petition and we file it in family court as an emergency and get a very, very expedited hearing.
Phil, when's the first time you see the judge? So you file this petition, and in our world right now, post-COVID, you can do that remotely, right? There's like a remote filing mechanism.
Yes.
So you file the petition, you do a detailed petition, as Don just said. Then what happens?
You could be in court the same day. If you file early in the morning, by the end of the day, you can be heard by a judge. And if the judge is concerned that your allegations do rise to the level of a family offense, a temporary order of protection will be in hand by the end of the day.
And who's present at this court appearance? So let me ask you first, is it remote or is it in person?
First, it depends on the court and the judge, but generally speaking, these days you can still do remote appearances in the New York City family courts on these, what Don referred to as ex parte applications. In other words, it's just you and your client, which is the answer to your question, I guess, and the other side's not there.
So they don't even know about it in the beginning?
They do not.
And do the judges want to speak to the clients or they just want to hear from the lawyers?
Typically, if you're well prepared and you've spoken with your client, they will just hear from the lawyers. But again, the judge runs the show. So if there's some question that remains unanswered and the attorney can't answer it, or the judge wants to hear directly from your client, they need to be prepared to speak a little bit. But generally, judges are very respectful of the attorney-client relationship. They're trained as well in trauma-informed questioning. So they are generally sensitive to that, and they don't really ask much of your client.
Dawn, are there particular types of orders of protection that you seek, or is it one size fits all?
No, there's an order that asks for exclusion of the person. For example, that would mean exclusion from the home, the place of business, the children's schools, anywhere within X amount of feet. That's called an exclusion. And then there's what's called a stay away. So a stay away doesn't kick you out of the house. It just says, you stay away from this person, don't harass, annoy, alarm them in any way. Otherwise, this order of protection will be violated, but you're still living together.
That's called like a refrain from, right? Refrain from.
Yes, refrain from.
Stalking, harassing.
Yeah. Once the word stay away are used, if it's stay away from the home, then it actually is an exclusion. That once those words go into the order of protection, there is a requirement that the person be removed from the home. That is the aggressor.
Phil, what about third-party communication? So your client gets an order of protection, but the family member, let's say it's a husband, the husband wants to communicate to her through family, friends, third-party communication. Is that allowed?
typically I ask when a judge issues an order to prohibit third-party communication, prohibit social media communication, pretty much prohibit any way for this alleged aggressor to correspond with or harass my client. So anything that would be under that umbrella, I would ask the judge to order not to happen.
Don, what happens when children are involved? Let's say you're in a situation, which I'm sure you've seen many, many, many times, when your client gets an order of protection, but the parties have children. They have young children at home. Maybe the children saw or witnessed the events giving rise to the order of protection, but maybe they didn't, but they're all living together at home. Are these orders on behalf of the children too? How does that work?
They would only be on behalf of the children if the children were victims of the domestic violence. However, I always ask for there to be a part of the order that says subject to any family court, orders of the family court. So this would allow us in the future to carve out ways, for example, of the father to see the children, ways to communicate only about the children. Typically, it can be, for example, if the family court allows it, you get to text the person, but you only get to text the person about the child, not about anything else. You know, we'll meet here, or the child is ill, or things that a parent might be entitled to. And that's how I typically ask the court in a criminal matter to do that.
What about, Phil, what about in family court? So you get this order of protection. So Don's saying, and if you go to criminal court, you get this carve out in family court. But what if you're in family court and the children or the child witnessed the domestic violence? They weren't victims themselves in the sense that the perpetrator didn't do anything to them, but they saw what happened to one of their parents. So then what happens then?
It's typically a judge will be inclined anytime what the child is in what they call the zone of danger. So which would be like what you're talking about, Dror, the witnessing type thing, to issue an order of protection that includes the children. If the children are old enough, they will actually get lawyers for those children. And sometimes I serve in that capacity. And those children, by the next court date, will have been interviewed by their attorneys, and they on their own will have a position as to whether they want orders of protection against their parent in that case.
I know you both serve as attorneys for the children. You both have done this for many, many years. You're the child's voice in many, many cases, such an important role. What is the age kind of marking? In other words, how old does a child have to be before the child gets an attorney appointed for her?
So, yeah, I don't know who you're directing the question to.
I don't know, Don, maybe you would give it a crack.
Sure. I mean, I would, if you want to make a generalization, I would say 5 and up. If the 5-year-old is a mature 5-year-old, I think younger than that, probably not. They would get a guardian ad litem.
What's the difference?
If necessary. A guardian ad litem is an attorney who is allowed to make decisions on behalf of the child and not follow what the child's request is, so to speak. Whereas an attorney for the child has an obligation to follow the instruction of their client, just as one would with an adult client, unless that child is impaired by mental health issues, by some psychiatric issues, impaired in some way in decision-making. So I would say 5 and up for an attorney and guardian ad litem for a younger child.
Phil, if you're in a situation where, okay, let's say mom gets an order of protection and the child witnessed it, and mom is saying, I think dad's parenting time needs to be supervised. I don't trust him to be alone with the child. Dad, of course, contests it, right? And contests all of it. I didn't commit the act of domestic violence. I'm a great dad. It's typically, this is the male-female dynamic, although there's plenty of holes in the cheese. So you get an order of protection, an attorney for the child is appointed. The attorney doesn't know, right? I mean, the child confirms, let's say, that there was an act of domestic violence at home. What happens in terms of the father's parenting time? Is it supervised? What does that look like?
There's a lot of ways something like that can be handled in family court. But when you file the initial order of protection, a judge can limit access based upon an application. But typically, the way that case needs to unfold is if the father wants access or the mother wants to limit access, just using your scenario, then one or both of them need to file petitions for custody and visitation. So this way, the judge could actually have that issue properly before him or her. Until that happens, the judge has some limited authority to make some orders under the order of protection in family court, but it's extremely limited. So that would be something a judge would probably push you to do if you haven't done at some point early into the proceedings, if that becomes an issue.
Don, let's say it's filed. So now you have orders of protection, custody and visitation filed. You have an attorney for the child appointed, and there's allegations of the necessity of supervision. Says mom, dad says my parenting time doesn't need to be supervised. Will the court at times appoint a supervisor for at least a period of time? Maybe not forever, of course, but for a period of time.
I think courts are very concerned and careful about the safety of children. I think initially they would have a supervisor appointed to supervise parental access with the parent in order to be sure that the parent is someone who will have boundaries in terms of what he says. The children are safe. They'll want to know how the children feel. What is the interaction like between the parent and the child? So yes, I do think that there will be supervision. I think that supervision is costly. And so what typically happens is that people who can afford supervision may get more supervised access with their child than people who can't afford supervision. And that I find is a terrible inequity. That a poor parent can only see a child once a week in a office with other children, as opposed to being able to have a supervisor come with them to the park, see them, even have them overnight with supervision. But yes, I do believe the judge would order supervision, and that's what would happen.
Phil, who are these supervisors? I mean, there's comprehensive family services. Who are these people?
They're generally licensed social workers that work for one of a number of organizations that can provide these services. But as Dawn said, it can get expensive fast. So really, initially, you're trying to figure out if the visits need supervision. And that is, the hope is if the DV issues are between the adults and the children really aren't involved, then the visits can happen without supervision with some kind of buffer for picking up and dropping off. So that's usually how that works. But there are licensed social workers typically that you're looking for to do these supervision
and they write
visits.
Reports to the court, right, to tell the court how the supervision is going.
They do, and those reports are shared with the attorneys who can all discuss it at the next court date after the report is issued.
Sometimes, Dror, there is a relative that they can both agree on, a grandparent, an aunt, an uncle, a good friend, whom they both agree they trust to do the supervision. And that's often a preferable way than, stranger supervision. Those people don't really write reports. I haven't seen it. But what I will do as an attorney for the child is just speak with them. First, speak with them about what's expected of them in terms of the supervision, and then form a relationship with them so that they have a place to go to if they have any concerns about what's going on with this child.
So I'm backtracking now. On day one, Phil, you get this order of protection, and the judge typically, because it's one-sided, there's only the person who got the order of protection and her lawyer. the perpetrator hasn't had his say in court yet. So what happens next, and how long does that order of protection remain in effect?
Well, it depends on one important thing. If the order of protection is one that is issued as a stay away that results in an exclusion of that individual from the home, that person's entitled to what's called an expedited hearing. So that case will likely come back before the court within the week. There'll be an initial meeting before the judge where that person will have an opportunity to...
And they have to be served, right?
Well, they have to be served. In either case, they have to be served, but it has to happen fast. Usually the sheriff can get involved or a process server, and that has to happen. But again, that's a relatively quick turnaround.
I'm interrupting, Phil. When the sheriff serves, let's say a sheriff or the police serves that initial order of protection, do they walk the person out? What does that look like?
If it's an exclusion, yes, they walk the person out. And another thing they will do is they check for firearms. There's a firearms provision typically in these orders. If the person has a firearm, they're empowered to remove it. If there's a license, it's suspended. And so that's basically this, the situation. They're walked right out of the house. They have to find a place to spend the next couple of days until they're in court.
And so the next court appearance, Dawn, is a really short leash, right? Like it's within a week because the person on the back end is subject to this extreme situation where they're forced out of the house and they haven't had their day in court. So what happens at that next appearance?
The judge confirms that the order has been served. And if that person has an attorney, that's when that attorney appears on his behalf. And then if he doesn't have an attorney, then the court will see whether or not financially one can be appointed, and one will be appointed that day. I typically find very little happens on that very first court appearance because it's short, and often there's an adjournment for the person to either decide whether or not this case can be settled, whether or not we're going to move forward on a hearing. If someone has just met their attorney that very day, they know nothing, they need an adjournment. So typically there is an adjournment. I find that courts want to keep it on a short leash for the very reason you said, Dror, which is somebody has been excluded from their home.
Phil, how long do these orders of protection, at least before a trial, how long do they last?
They can last a very long time. The family courts do their best to move these cases along, but between attorney schedules and judges' calendars, and also there's criminal cases that may intervene that people need to, if someone's, say, accused in a criminal court, they may not want to rush a family court case along where they have to testify. So it's not uncommon for a case to take 6 to 18 months, and that's a wide range, I know, but it's not uncommon.
Just this issue with testifying. So if you have somebody who is a alleged perpetrator in family court and who is a defendant in the criminal court, that person cannot testify in family court because whatever they say can incriminate them in the criminal court. So the family court presumably will extend the family court case till things play out in the criminal court.
Well, it's not actually a great presumption. It really depends on the judge.
Right.
There's case law that makes it pretty clear that judges don't have to wait. It's a discretionary thing. And ultimately testifying, they view it as a civil proceeding where there's no Fifth Amendment or, right to remain silent there. If they exercise that right there, then they're doing it, in a proceeding where at the end of the day, there'll be a negative inference taken against them. It's a very complicated area. I don't necessarily agree with some of the way it's handled, but it's not up to me to agree. The courts have spoken, and generally at this point, while if I represent somebody who is on that side of it, I would not let them testify in criminal court, regardless of in family court, if they have a criminal case pending, regardless of what the consequences may be, and hope that the judge will delay the family court case. But you can't assume that's going to happen. You could try, but you can't assume.
Dawn, so these orders of protection generally last from court appearance to court appearance, right? And you go to court every 2 or 3 months to kind of see what's going on with the parties, with the children. And then ultimately there's a trial scheduled where people testify and there's evidence. And what happens during that process when you get the initial order of protection up until the time of trial, which, as Phil said, could be up to 18 months? What happens when somebody violates the order of protection?
Well, when someone violates an order of protection, you immediately file, that person can be arrested for violating an order of protection. So it can go to criminal court, and then you make an application in family court for the violation, and the judge can, again, hold a hearing or wait until the criminal case has been resolved. But it is, it's an automatic arrest if you violate. And it's a more serious crime, obviously, if you violate an order of protection.
Phil, how long, so after a trial, which is where evidence is presented, and of course, Don.
Could I just say one other thing? Sometimes, and Phil, I don't know if you've had this experience, probably have, all of us have, where we are sort of encouraged to settle the matter. Typically, it's in a case where there's a matrimonial going on. And typically, the suggestion is that the parties consent to the order. And that consent is they neither admit nor deny what they've done. It is a civil order. And I call it a little bit of a lesser order of protection in a way. But often we are pressured, I think, to settle these orders in a consensual situation.
Phil, do you find that as well?
I find I won't say pressure, because I don't accept pressure. I will do what I have to do. But we're definitely encouraged, I would say.
You appreciate the sentiment, though.
But yes, I definitely feel the same encouragement to try to resolve these cases. And sometimes it makes sense to do that. Sometimes it makes sense to do that for your client who doesn't have to testify in court and deal with more trauma. So there are merits to doing it that way. But at the end of the day, each case is different, and it just really depends upon what the situation is.
Phil, how long, let's say the victim wins after a trial, how long do these orders of protection last?
They can last up to 2 years for a basic order of protection from the date of the decision, or if there is a situation where you have a aggravating circumstances, how they define it in the court. In other words, something more serious happened than just some argument or some pushing around where maybe blood was drawn or something more serious like along those lines happened, or there was a violation of a prior order. Those types of elements in your case can result in a request for up to 5 years. So you can seek up to 5 years. Those are harder to secure, but there is a very clear law as to when you can ask for those things.
So these things are not permanent, right, Don? You can't get an order of protection forever.
You can't get an order of protection forever. However, if you have a violation, you can get a new and extended order. I do know of one case where someone got a 20-year order from a judge in a really, really egregious situation, but they do not last forever. And that is concerning because, I once had a case representing a little boy whose father was incarcerated because he stabbed his mother in front of him. And he was brought down from prison because he wanted to have a relationship with this son who wanted nothing to do with him. And after seeing him testify, I said to the mother, he's going to get out of jail someday. You better move.
Wow. So let me ask you, do you believe, based upon your experience in the courts for so many years and representing so many clients, that in the majority of these cases involving domestic violence, justice is being delivered in the New York courts?
That's a great question. I mean, I know, I suspect Dawn feels the same way I do. I mean, I don't know, what is justice? I mean, we could have a 4-week podcast on what is justice. So do I believe, what I would answer...
Use your gut, Phil, your gut. What does your gut tell you?
The court does a good job, but it can do a much better job, is what I could say. So justice is served to some extent, but we need to all do better to make sure that justice is served more frequently, more consistently, and more expeditiously.
What about you, Don? In your experience, is justice delivered in these cases?
Again, I kind of am a little bit afraid of the word justice, and I tell my clients I don't know that they're going to get what they think is justice. But what I do think is that Yes. Do we do the best we can? Yeah. I don't know that the best we can is even close to being good enough. I don't think that there's enough training of judges on domestic violence beyond the perfunctory. I do think they care. It's not about caring. I think that we need more supportive services for victims of domestic violence, for the children, and even for the perpetrators. You know, they don't disappear, especially if it's a family and there's children. So I think that, you know, we could do better. I feel as if in the matrimonial part, we don't do as well. I don't think they really understand coercive control. And I think that the judges, and not intentionally, not because they're bad people, but the nuance of coercive control in a matrimonial case is often lost on a judge or isn't considered serious by a judge. And therefore, the client does not get what she deserves in terms of a result and in terms of being able to use it, as the statute says, in the settlement of spousal support, in the settlement of equitable distribution. So I think we could do a lot better in training our judges and our attorneys to more fully understand and credit domestic violence, and really in the area of coercive control, and not minimize it.
That's why we have people like Phil Katz and Don Cardi, my rock star colleagues, who are leaders and lecturers in this area of law, including teachers of the judges, which is so important. Thank you again, Don Cardi and Phil Katz, for being guests on this podcast. Don Cardi's firm can be found at Cardi Edgar Law, CardiEdgarLaw.com. Phil Katz's firm can be found at finkatz.com. That's FINKATZ.com. Thank you, listeners, for tuning into this episode. If you or someone you know is a victim of domestic violence, please know that help is available, and please call the National Domestic Violence Hotline at 1-800-799-7233.